To you live from Milimani Locals, whereby it's a D-Day for Kenyans at large, as the three-judge bench led by Justice David Majanja are giving their decision on the Finance Act 2023 that was filed by Okiya Omtata and his co-petitioners in June this year. The decision has taken around 5 months for the verdict to be delivered today. And the three-judge bench, when it entered the courtroom, it has declared as section 84 of the housing levy as unconstitutional, and therefore it has also declared that KRA collecting the funds is also unconstitutional, and that the CS for lands should appoint CS. It is not the KRA that's supposed to collect the funds, rather than it is the CS for treasury that is supposed to collect the funds. The bench has also agreed on some of the decision. It has agreed with the respondents, and other decision it has agreed with the petitioners. And to join me on this discussion is Evans Ogada from the Law Society of Kenya. Evans, welcome to Lunchtime Live Bulletin. Kindly tell us, how has the decision by the three-judge bench favored you or not favored you?
Thank you very much. On this, I was not with the Law Society of Kenya, but I was with Siasa Place and Tribeless Youth in Petition 238. Basically, this has been a mixed bag. We see the court largely disagreeing with the petitioners on the constitutionality of a raft of taxes, including the digital tax, but largely has agreed with us in terms of the housing fund. So it's a mixed bag of emotions. Both sides are going to look at the decision. I am certain it's going to go to the Court of Appeal. We are going to take instructions from the clients. Mm-hmm. Yes.
And what about on public participation? The bench has said that the National Assembly conducted sufficient public participation to the members of the public. What's your take on that?
Well, we had Justice Meoli reading that segment for the court, and the judge examined the test in the BAT case by the Supreme Court. We will be waiting for the written decision, the judgment in its full tenor, to see whether indeed the BAT test has been met. For us, and certainly my co-counsel in Petition 238, Dudley Ochiel, we are aggrieved by that determination. We certainly think that public participation was perfunctory. We are going to consult the clients. We will see whether to petition to go up higher to the Court of Appeal. Mm-hmm. Yes.
And I've also seen you asking the court or praying to the court to order that reimbursement be done on the housing levies that has been done so far. And the bench has retired to go, and it will come back to tell us whether it will agree with you guys or not. Why are you on that?
Well, it was the position of the respondents that this money can and indeed can be refunded. Our application for reimbursement is grounded in law. When you have a declaration of unconstitutionality, then that very basis for collecting the housing fund does not stand. So it is only proper that the reimbursement happens. We have made our submissions to court. Let's see what they will give us at 3 o'clock. Mm-hmm. Yes.
Okay, let's see you at 3 o'clock.
Thank you very much.
Well, studio, as you've heard it from Evans Ogada, that's what has transpired the whole of this morning and early afternoon at this court. Now the three-judge bench has retired to go have lunch and also deliberate on ruling on whether a stay order can be put on the matter of the that has been placed by the respondents and petitioners. So we wait at 3 p.m. to see how the judge will lean on which side, whether it will favor the petitioners or the respondents. Back to you, Abdiaziz Hashim in studio.
Thank you so much. That is Ruth Wamboi, and of course we'll come back to you live once more once the three judges take to the podium again, and of course to give that particular verdict, given that Tharaka Member of Parliament and the council in that particular case had asked the judges to give a 45 days stay so that the government can mull over the decision that has been made, especially on the housing levy.